Officer Dave, would you open the courtroom, please?
Yes, can I?
The State of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session.
Okay, so
Good morning, everyone. Good morning, Your Honor.
Good morning. All right, I think we're ready to begin. This is file number 11-102008, Discover Bank versus Krista Montgomery. Your respective appearances.
Thank you. Good morning, Your Honor. Daniel Best, P585001 on behalf of plaintiff Discover Bank.
And what is your name, ma'am?
My name is Krista Montgomery.
Ma'am, we are here for your motion for relief from judgment and objection to ex parte motion to renew the judgment. Please proceed.
I'm before you today requesting relief from the plaintiff's ex parte motion in order to renew civil judgment that was granted last month on February 8th and a dismissal of the plaintiff's complaint filed in January of 2011. The plaintiff has failed to provide any proof substantiating their claims. First and foremost, there is an account number discrepancy and the plaintiff has not provided proof that their 2011 complaint was for the correct account. Additionally, in 2016, the plaintiff stated to the court on the record and continues to submit via paperwork that the default judgment granted from their 2011 complaint has been satisfied. However, because they filed a motion to continue their collection efforts, I don't want to waive my right to raise a defense. On the face of the pleading, plaintiff's complaint appears to be account stated. However, in their response to today's motion, they have affirmed that it's breach of contract. As such, MCR 2.113C1 applies, which requires proof of a claim based on a written instrument to be attached to the pleading. Therefore, the plaintiff was aware that the attached affidavit supporting an amount stated was inadmissible as evidence of indebtedness, as their claim is not account stated. However, proof of how the total debt was calculated was required to be attached and was not. Proof of offer and acceptance of an agreement was required to be attached and was not. Plaintiff claims that usage of the card created an implied agreement. They have not provided proof of that usage to create that implied agreement. Plaintiff stated that the agreement they attached was issued on December 15th of 2009. The Truth in Lending Act requires a 45-day advance notice to the changing terms of an agreement. This means based on the plaintiff's assertions, the attached agreement would not go into effect until February 1st of 2010. Plaintiff has not attached any documentation showing usage of the card from February 1st of 2010 or thereafter to support their claim that usage created acceptance of new terms. Failing to attach the proper agreement, which would reflect the legal obligations of the parties involved, is a violation of the Truth in Lending Act. This is all in addition to the fact that I was never served with a summons and complaint, and my signature was forged on the proof of service, stripping me of my right to challenge all of their inconsistencies before a judgment was entered. For these reasons, and for the reasons that I set forth in my objection and motion, I'm asking that the court relieve me of their judgment and the underlying complaint that they filed.
Your response.
Thank you, Your Honor. Your Honor, defendant raises things that have all been raised before. She sought to set aside the default. This court denied that motion. There is a default judgment that's valid, outstanding, and has not been paid. At this point in time, her only defense to the judgment was that she had paid it or it was otherwise discharged. That simply is not the case. Defendant's motion is wholly frivolous, and we're requesting not only the court deny it, but that we be awarded our attorney fees for having to read, respond, and attend today's hearing.
Anything you want to say in rebuttal, ma'am?
Yes, where is the proof of their claims?
Okay, anything else?
No.
All right, thank you. The court has had an opportunity to read the pleadings filed both on behalf of the defendant and the responsive pleading filed on behalf of the plaintiff in this matter. Significant to me is the fact that on May 25, 2016, court held a hearing and denied a motion to set aside the default judgment filed by the defendant. This matter has already, the question of the validity of the judgment has already been decided. After that May 25, 2016 decision, the defendant had the right to appeal the decision or had the right to file a motion for reconsideration. Neither of those things were done. And now, several years later, the defendant files an objection to the renewal of the judgment determined on that May 16th, 2016 date to be valid. Court finds that the plaintiff is, the defendant is not entitled to the relief that is being requested here. The question of the validity of the judgment has been settled since at least May of 2016. Therefore, the motion filed on behalf of the defendant for relief from judgment is denied. The motion filed on behalf of the defendant seeking to set aside the renewal of the judgment is denied. The defendant's request to set aside the default judgment is denied. The defendant's request to dismiss the complaint is denied. You have an absolute right to appeal my decision. That appeal must be perfected in 21 days of today in the Wayne County Circuit Court. Mr. Best, please submit a 7-day order on this matter.
I will do so. Thank you, Your
Thank
Honor.
you both for coming in. We are off the record.
Thank you. Have a good day.
You two both. Admit all. All right, good morning. Let's see what we have here. Mr. Nate, why are you here today?
Looks like we have a pretrial with LVNV funding versus Kelly Kauser.
Okay, I have you here. I do not have your opponent, so you're off to the waiting room.
Okay, yeah, that's fine.
Ms. Nonis,
Good morning, Your Honor.
how are you?
I've got 343 asset acceptance versus Jacqueline Jackson.
Okay. You likewise do not have an opponent at this time. So off to the waiting room with you.
Okay,
And Mr. Stratton,
Good morning, Your Honor. 764, Dominique Walker is the defendant.
okay. You have a motion to reinstate the file, but you do not have an opponent. Off to the waiting room with you.
All righty.
Cool. Easter.
Good morning, Your Honor. Preston Nate, P77884, appearing for LVNV funding.
All right, we have no answer. I mean, the defendant has failed to appear. Have you had any contact with the defendant?
We have not, Your Honor. I'm not even sure we received a copy of her answer, so I'm not sure where they stand on this case.
Okay. Well, what I'm going to do, Mr. Nate, is I have your proposed default, which was came in. I will simply enter the default judgment. The defendant has failed to appear. No good cause, that failure having been shown. Judgment by default is interest paid for in this case. We'll send you a copy and you're all done, sir. Thank you for coming in.
Very, very good. Thank you, Your Honor. I appreciate it. Have a great afternoon.
You too, sir. We're off the record. We are on the record calling file number 163764, Dearborn Total Automotive versus Dominique Walker. This is the date and time for a motion filed on behalf of the plaintiff to reinstate the case. By a notice dated February 18, 2021, this matter is set for hearing today, March 5 at 10 o'clock. It's currently 10:33. Your appearance.
Morning, Your Honor. Trevor Stratton, P65124 on behalf of the plaintiff.
Mr. Stratton, the defendant has failed to appear. Have you received any pleadings from the defendant?
I have not.
Your motion.
Your Honor, this is a matter where I actually received the notice of hearing on the same date that I received the order of dismissal.
Makes it kind
The
of hard.
notice got, I'm sorry?
Makes it kind of hard to come for the hearing if you get it.
It does make it hard, yes, and that's the reason I wasn't there, and simply as that, I'm asking for the case to be reinstated and a new pretrial to be scheduled.
All right, Mr. Stratton, you have supported your claim that you didn't get timely notice with an exhibit attached to your motion. I note for the record that neither party appeared for the pretrial, so reinstating the case could not generate any prejudice to the defendant. Your unopposed motion to reinstate the case, sir, will therefore be granted. We're going to set the matter for pretrial March 29 at 10 o'clock.
March 29 at 10 o'clock.
Okay?
Thank you, Judge.
Thank you, sir. We'll send out the notice of the pretrial and send out the order reinstating the case today.
Great. Have a great weekend.
You too, sir. We're off the record. We are on the record calling file number 0811833. The file is entitled Asset Acceptance versus Jacqueline Jackson. By notice dated February 17th, 2021, this matter is set for hearing on a motion today at 10:30. It's currently 10:36. Your appearance.
Good morning, Your Honor. Attorney Ashley Nonis, P77029 for plaintiff.
Ms. Notice, have you received any pleadings on this file from the defendant?
We have not, Your Honor.
Your motion.
Thank you. So today is the date and time for a motion to reinstate the case and enter a tax garnishment. There seems to be, back in 2014, a notice of bankruptcy for this defendant. However, I believe it was applied to the wrong file because I've pulled a PACER bankruptcy report both when I filed this motion as well as today, and there is no record of any bankruptcy for the defendant with her SOCH or under her name. So with that being said, I did attach a copy of that to our motion, Your Honor, the PACER report. I would ask that the case be reinstated so we can file our tax garnishment.
It appears that somewhere down the road, a clerical error was made because we, of course, enter our bankruptcy stage based upon submissions to us, typically by counsel. We got looking back on the Register of Action, it appears that on July 23rd of 2014, we got an order for bankruptcy stay, typically prepared by counsel for plaintiff, rarely by the defendant. In any event, your motion is unopposed. You have supported your motion with a PACER search indicating that no bankruptcy has been filed for this individual. Therefore, your unopposed motion will be granted. We'll send out your order today. Thank you for coming in.
Thank you, Your Honor. Have a good weekend.
You also. Both sides. All right,
Can you hear me?
okay, we are on the record. This is case 20156-539. Security Credit Services versus Donita McQueen. This is a date and time for pretrial. I know when we were last together on January 29th, the court closed written discovery as of yesterday. Your respective appearances.
Good morning, Your Honor. Brad Johnson, P75416 on behalf of the plaintiff.
And what is your name, ma'am?
I'm Donita McQueen.
All right, where are we on this file, people? Discovery is closed now.
Your Honor, we sent in a motion for summary disposition back in late February. I don't see it on the court's register of actions. But we did send Ms. McQueen a copy as well.
Did you receive that motion, Ms. McQueen?
What does it look like? Just in the beginning, the very first paper?
No,
Is that what he's talking about?
we're talking about something very recent.
No, I haven't received anything from them. No.
Okay.
What day did you mail it, Mr. Johnson?
It's been the 23rd of February.
Okay, I don't have anything. She doesn't either.
Okay.
So let's do this. Let's set this for a hearing date on April the 9th.
April the 9th. Okay.
And then you send out notices again to send out copies of pleadings again to everybody.
Okay. With the
That
new
works.
What time?
April 9th, it'll be 11 o'clock, ma'am, like today.
Okay.
We'll calendar the plaintiff's motion for summary disposition for April 9th at 11 o'clock. And then send out, notices again to everybody, copies of the motion as well. With proof of service.
Okay, do I need to send another check?
No, if you sent the check, it'll eventually catch up,
Okay.
but it has not as of yet. So, in essence, treat it as an extra judge's copy along with proof of service on Ms. McQueen for, March 5th or whatever day you send it out on.
Gotcha. Okay.
Everybody in place at one time, we'll be sure that she has a copy and an answer, an opportunity, ma'am, to file your answer in response to that motion, okay?
Okay.
Okay.
All right, so we're gonna set plaintiff's motion for hearing, April 9th, 2009 at 11 o'clock will be plaintiff's motion for summary disposition. Thank you both for coming in. We're now off the record.
All right. Thank you, Your Honor.
Bye-bye. You too.
Good morning.
Good morning.
You've got two motions to set aside satisfactory judgment.
Yes.
Yeah, I don't have the other side as of yet, so I got to give a few more minutes. I'll put you in the waiting room. It come for you no later than 11:30.
Okay.
Okay?
Thank you. Yep.
Hello?
Hey, Your Honor, it's Carrie. The file that Erica was talking to you about early this morning,
Yeah,
Roscoe called me on, and he's a little confused of what you wanted, so he said, what did you want? Did you want the dismissal back out there, or?
I want to see what the original was before. At some point in time, there was obviously a dismissal, right?
Yes,
And I want to know why the dismissal was taken out, who took it out.
let me call him back then. Okay,
Yeah,
thank you.
thank you.
Okay, bye.
Yes,
Roscoe wanted to explain to you, he wanted to know what time. I told him 11:30 when you're done with your last case.
that'd be great.
Okay, in the courtroom, okay?
In the courtroom, thank you.
Yeah, thank you.
Bye-bye. Then you enter. He's a stupid. Okay, we are on the record calling file number 06142979, asset acceptance versus Kenyatta Pritchard. By a notice dated February 5, 2021, this matter set for hearing today, March 5, at 11 o'clock on the plaintiff's motion to set aside satisfaction of judgment. It's currently 11:30. Your appearance.
Omar Najer, P 58066, on behalf of the plaintiff.
Have you received any pleading from the defendant here?
Sorry, Judge, I didn't hear you.
Have you received any pleadings from the defendant in regard to your motion?
Have I received a response?
Yes,
No, I have not received any response.
we have not either. Your motion.
Your Honor, it appears somehow we tried to file, I think, a garnishment and then got notice that it was rejected. There's been a satisfaction of judgment. Shows on the ROA, but our office is saying that we never asked for a we never prepared, mailed one, never had generated. So we don't know how the court's file says the satisfaction of judgment. We're asking that to be removed. If you look at it, satisfaction judgment was filed apparently, or in the ROA, according to the ROA, on October 3rd, 2018.
Yes, sir.
But then I believe Your Honor granted our motion to renew on October 23rd, 2018. So there's,
Well, the two of those.
we don't have anything that shows that we filed a satisfaction of judgment or requested one.
All right, and how much have you received on your judgment?
I'm sorry, Judge, I'm having a hard time hearing you.
How much have you received on your judgment?
On the judgment, give me 1 second. This is the Pritchett matter. Let me see when it was the judgment date. I show $672.34. I just want to make sure that was all post judgment. Got a garnishment payment back in 2009, $662.34, and then there was appears to be a personal check payment in 2005 for $10. Let's see, when did the judgment actually get granted?
Judgment was entered January 3rd, 2007.
2007. Let me go back to, what did I say, oops. Yeah, so it's just $662.34 is post judgment.
All right, well, your motion is unopposed. The amount that you've collected is certainly less than the amount of your judgment. Your motion to set aside the satisfaction of judgment, which was entered on October 3rd, 2018, will be granted.
Thank you, Judge.
The next case we're going to call is case number 07-129-826, asset acceptance versus Lolita Taylor. By a notice dated February 5, 2021, this matter set for hearing today, March 5 at 11 o'clock on the plaintiff's motion to set aside satisfaction of judgment. It's now 11:34. We have an appearance by counsel for plaintiff. The defendant has failed to appear. Mr. Najer, has the defendant Taylor filed any pleadings in response to your motion to set aside the satisfaction?
No, Your Honor.
Your motion.
Similar to the last motion, it appears there's been a satisfaction of judgment per the ROA. Our records do not show that we requested or generated one at all. That satisfaction judgment appears to have been entered on April 3rd, 2017, but just looking from the ROA, the court accepted and filed our lien shortly thereafter on April 26, 2017, and a motion to renew judgment was granted on May 5th, 2017. In this case, I don't believe we received any payments regarding from Ms. Taylor. There's been no payments received.
Your unopposed motion, sir, will therefore be granted. Court will enter the orders that were submitted along with your proposed motion, proposed orders submitted with your motion and send them out today or tomorrow Monday. Thank you for coming in. We're off the record.
Have a good day. Have a nice weekend.
You too, sir.